judicial judicial powers of a bench of the Supreme Court to form to direct formation of the full court. So that is a precedent. Otherwise, when this matter was before them, it was challenged even that Chief Justice has not formed this bench. How come you have formed the bench? The answer came that on the judicial side it could always be done. But if it has to be done on the administrative side, it has to be Chief Justice.
अगर इस तरह समझ लें खान साहब, जुडिशल साहब आपकी बात मान लेते हैं, फर्ज करें अगर आपकी बात मानते हुए हम ऑर्डर कर देते हैं कि तमाम जजेस जितने भी सुप्रीम कोर्ट के हैं, दे शैल बी मेंबर ऑफ द कॉन्स्टिट्यूशन बेंच, वुड यू बी सेटिस्फाइड?
Member of the Constitutional Bench.
सारे
satisfied if
बेंच का हिस्सा बने, पर आप सेटिस्फाई होंगे?
हिस्सा बना है कॉन्स्टिट्यूशनल बेंच का जो तस्वर है वो आपने 26वीं तरमीम के तहत दिया है।
हमने नहीं किया, पार्लियामेंट ने किया, हम पे ना डालें। पार्लियामेंट
उसी को तो हम चैलेंज कर रहे हैं।
ठीक है, हो सकता है आप सक्सीड कर जाए, हो सकता है आप सक्सीड कर जाए या ना कर जाए।
एक मिनट के लिए आप 191A को भूल जाइए, फॉर द रीजन दैट वो तो अंडर चैलेंज है ना सर। तो आप ये देखिए हम वहाँ खड़े हैं जहाँ
अगर 191A को भूल जाएं तो फिर तो कॉन्स्टिट्यूशन बेंच का तस्वुर ही खत्म हो गया। फिर व्हाई वी आर सिटिंग हियर,
फिर तो हम
कॉन्स्टिट्यूशनल बेंच इंटरनल बेंच
खत्म हो गया उसका। देयर इज नो कॉन्स्टिट्यूशन बेंच।
खान साहब सुनिए, देन देयर इज नो सुप्रीम कोर्ट इन द कंट्री टुडे। There is no Supreme Court.
That's what we are saying. The Supreme Court is there.
नहीं है तो फिर
ये कॉन्स्टिट्यूशन
अगर आप 199 को अगर आप 191A को नहीं मानते हैं, फिर तो ये बेंच खत्म हो गया।
बेंच क्या? सुप्रीम कोर्ट इन द कंट्री।
आप कह रहे हैं उसको भूल जाए, हम भूल लेते हैं, चले हम भूल लेते हैं, आपकी बात मानते हैं, हम भूल जाते हैं, एक साइड पे रख लेते हैं, फिर तो ये बेंच खत्म हो गया।
खत्म नहीं होता। It's still a bench of the Supreme Court.
This is a creation of Article 191A1 and A4.
Even today Supreme Court is under Article 191.
फिर आपको पार्लियामेंट को अप्रोच करना पड़ेगा कि एक फुल बेंच बना के एक
फिर कोर्ट बना है। पहले तो सुप्रीम कोर्ट
पैदा हो सकती है, बट थिंग्स हैव टू बी रिजॉल्व जुडिशली, और इसको जुडिशली, वरना अगर हम इससे बाहर निकल गए तो फिर हमारी जुडिशरी बिकम्स टोटली मीनिंगलेस। तो हु विल सपोर्ट? बात यहाँ पर जो हम कर रहे हैं, ये 26th अमेंडमेंट इज एन अटैक ऑन द इंडिपेंडेंस ऑफ जुडिशरी। दैट्स व्हाट माय आर्गुमेंट। इसको प्रोटेक्ट करना, इस कोर्ट को और इसकी इंडिपेंडेंस को, ये सुप्रीम कोर्ट का अपना काम है, और इसलिए हमारी सबमिशन है, आप कॉन्स्टिट्यूशनल बेंच नहीं, आप 8 मेंबर बेंच है इस ऑनरेबल कोर्ट का, और आपने हमारी सबमिशन को एक्सेप्ट करते हुए 16 मेंबर बेंच यानी फुल कोर्ट दैट एग्जिस्टेड द टाइम ऑफ पासिंग 26th अमेंडमेंट, उसका जुडिशियल ऑर्डर पास करना है।
इग्नोरिंग
इस बेंच को चीफ जस्टिस ने या जो प्रैक्टिस एंड प्रोसीजर कमेटी ने नहीं बनाया। ये बेंच उसके तहत बना ही नहीं है। तो अगर आप उसको नहीं मानते फिर तो इस बेंच का वजूद ही खत्म हो गया। फिर हम ऑर्डर कर ही नहीं सकते।
हम तो आपके सामने जुडिशियल ऑर्डर सीख रहे हैं।
देखिए ना,
ये बेंच नहीं कर सकेगा।
हम भी 191 को इग्नोर करें कि वो जुरिस्डिक्शन जो अंडर द कॉन्स्टिट्यूशन सिर्फ कॉन्स्टिट्यूशनल बेंच को है, हम बाकी जजेस को मतलब कन्फर करें बाय ऑर्डर ऑफ दिस कोर्ट to hear these petitions.
तो 191A जो है वो तो फिर infructuous हो गया ना, it has become redundant, and before hearing you it amounts to making it redundant unless you argue the whole case at the relevant time, and we will reach to the conclusion whether it is against the basic structure or what are the defects in the amendment. That would be a different story. But right now you know that you are very senior counsel. Article 5 of the Constitution, loyalty to the state is the basic duty of every citizen. Obedience to the Constitution and law is the inviolable obligation of every citizen, wherever he may be, and of every other person for the time being within Pakistan. Yes. 191A is a part of Constitution presently, unless it is treated otherwise or struck down at the final stage of the case. But right now it is the part of the Constitution. And you say that ignore it and make the full court. How within that jurisdiction we can do this? I am asking this for last many
सर, मेरी गुजारिश है कि मैं बारहा अर्ज ही कर रहा हूँ कि आपको 1 मिनट के लिए ये तस्वर करना पड़ेगा कि आज कल 26वीं तरमीम पास हुई, अब इस पर कोई एक्ट ऑन नहीं हुआ। तो अब देखना ये है कि ये जो 26वीं तरमीम है क्या ये आइन के बेसिक स्ट्रक्चर के मुताबिक है कि नहीं?
That will be seen at the relevant time when you will argue the case on merits.
इसलिए
But right now this is question of bench. You are asking us to do something which can be do under the constitution. Please satisfy on this point.
सर वो हम उस पर सेकंड स्टेज पे आएंगे. मैंने पहले ही कहा ये जो कुछ भी मैं सबमिट कर रहा हूँ ये फुल कोर्ट फॉर्मेशन के हवाले से है, क्योंकि इम्पोर्टेंस ऑफ द सब्जेक्ट बिफोर योर लॉर्डशिप इज सच important one that only half of that full court is at present before us. We are only seeking that please also include the other learned 8 judges who were judges of this honorable court at the time when 26th amendment was passed. This is nutshell of my submission. और इसके लिए I am trying to take precedent. आपके पाकिस्तान के प्रेसिडेंट क्या है
बताइए.
मैं आपको ब्रीफली सारे प्रेसिडेंट बता देता हूँ जिनमें हमेशा फुल कोर्ट बनी है. जहाँ भी इम्पोर्टेंट कॉन्स्टिट्यूशनल क्वेश्चंस अराइज हुए हैं वहाँ पर फुल कोर्ट बनी है. ये तकरीबन 70 साल की बात है. आप देखिए पहला जो इस किस्म का केस है वो आप सब जानते हैं, फेडरेशन ऑफ पाकिस्तान वर्सेस तमीजुद्दीन खान, PLD 1955 फेडरल कोर्ट 240. It was consisting of full court. At that time Supreme Court's sanction strength was 5 judges. One incident I'll just point out for the sake of history. One of the learned judges was, however, not available. Justice Shahabuddin. He had been given an assignment as additional governor of East Pakistan. In his place, they completed the quorum of 5, the strength of 5, by taking an ad hoc judge. At that time, the Chief Justice of Lahore High Court, Justice S.A. Rahman. So again, full 5-member bench decided this case. Then, sir, next case which I'll be referring to, I'll give the list also tomorrow.
Yes, yes.
Jubindra Kishore versus Province of East Pakistan. This was relating to the Vices of East Pakistan State Acquisition Tenancy Act. A very important
Citation,
constitutional question.
Citation क्या है इसकी?
Citation, sir, PLD 1957, Supreme Court 9. By that time, the 56th Constitution had come into existence. It was again full court.
What is the third
The
case?
third case, State versus Doso, PLD 1958, Supreme Court 533.
553.
533.
Right?
This 533.
Okay.
At this time, there were only 4 judges of the Supreme Court. One of the judges of vacancy was there. So this was a case heard by 4-member bench. Full court for all intents and purposes. That was the available judges of the Supreme Court. Then next, very important case again, question of interpreting the Constitution, was Fazlul Qadir Chaudhary versus Abdul Haq, PLD 1963. Thank you. PLD 1963, Supreme Court 486. In this case, a statute was struck down because it was against the Constitution, and at that time it was provided under the Constitution that a minister cannot be a member of the Parliament in a presidential system. But in the garb of resolving the difficulties, the provision of the 62 Constitution, they allowed the ministers to retain their membership of the Parliament. This was struck down by the Supreme Court, by a full court, at that time 5-member Supreme Court. Then, sir, next important case in this regard is Maulana Maududi versus Government of West Pakistan, PLD 1964, Supreme Court 673. in which Supreme Court set aside the notification by the government declaring Jamaat Islami as unlawful association. Again, a case, constitutional case of national importance. Then, sir, next case I'll be referring, Province of East Pakistan versus Sirajul Haq Patwari. PLD 66, Supreme Court, 854. Again, all 5-member bench decided relating to the election of certain functionaries under the basic democracies model. So therefore, again a full court. Then the next important case is Asma Jalani versus Government of Punjab. PLD 1972, Supreme Court. Next important case is Asma Jalani versus Government of Punjab. PLD 1972, Supreme Court 139.
एक मिनट रिपीट कर दीजिए प्लीज.
जी सर.
रिपीट कर दीजिए PLD.
Yes, 1972, Supreme Court 139.
ये आसमा जिलानी होगी ना.
This was where the martial law and the consequential acts which were performed by General Yahya Khan was declared as illegal, unconstitutional and invalid. The 5-member court and all 5 judges sat there. The next important case is the state versus Ziaur Rahman. PLD 1973, Supreme Court 49. Again, 5-member bench, all 5 sat to decide this case. Then next, Begum Nusrat Bhutto versus Chief of Army Staff. PLD 1977, Supreme Court 657. Sir, at that time, the strength of the court was 9 judges, including the Chief Justice. All 9 of them heard and decided this case. And next case is Federation of Pakistan versus Haji Muhammad Saifullah Khan. PLD 1989, Supreme Court 166. At that time, the strength of the Supreme Court was 12 judges, including the Chief Justice. They all heard this case together, and in which it was decided, upheld the judgment of the Lahore High Court, but did not allow the election to take place, allowed the election to take place and did not restore the government of Mr. Junejo. Then important case in this about the dissolution of the assembly headed by Benazir Bhutto Sahaba. This is it is Khaja Ahmad Tariq Rahim versus Federation of Pakistan. PLD 1992, Supreme Court 646. At that time, the strength of the Supreme Court was heard this case. Then, sir, Next case is Muhammad Nawaz Sharif versus Federation of Pakistan. PLD 1993, Supreme Court 473. At that time, the full court consisted of, or available judges were 11 judges. This decision was taken by all 11 members of the court at that time. Then, sir, these 90s precedent. Then, sir, Asad Ali's case, Malik Asad Ali versus Federation of Pakistan, PLD 1998, Supreme Court 161. In my humble submission, this is one of the most relevant cases in the context of Pakistan, because there the question was what should that whether the appointment of then Chief Justice was valid or not, and therefore all the judges available, those there were 5 or 6 other judges, Chief Justice did not become part of or was not made part of this bench, and so Justice Ajmal Mia also recused from there. So these 10 judges were the available judges and formed a full court, and that's what they explained, because they even explained in this judgment that 7 judges could not sit on the bench and had recused, and therefore only 10 members are available as full. Then next case, Chief Justice Iftikhar Muhammad Chaudhry versus President of Pakistan. PLD 2010, Supreme Court 61. Now this was decided by 13 members, but a full court. Others had recused. Actually, the Chief Justice's case, so he could not sit, and so were some other judges not available. So the available judges were 13 judges. It was formed a full court, and case was decided by this full court consisting of 13 members. Then, sir, next important case was Bashar Hassan versus Federation of Pakistan. इसमें सिंध हाई कोर्ट बार एसोसिएशन का केस है सर, है कहाँ पर है? Sir, sorry, next case which I like to refer to is Sindh High Court Bar Association versus Federation of Pakistan.
Petition बताए.
Sindh High Court Bar Association versus Federation of Pakistan. PLD 2009, Supreme Court 879. Decided by full court of 14 judges. At that time, this may kindly be taken as precedent, there were about 15 other judges who had been appointed under provisional constitution order. So the question was whether they could form part of the bench, full court or not. So the answer was that since the very provisional constitution order was under challenge, and those appointed under that, they could not sit under it, and therefore only 14 judges who had not taken oath under PCO were available and was considered as full court and decided the matter. Then, sir, next, Mubashir Hassan versus Federation of Pakistan. PLD 2010, Supreme Court 265. This was decided by all 17-member full court, where the vires of National Reconciliation Ordinance 2007 was struck down, was under question and it was struck down. Then, sir, next very important case was Nadeem Ahmed versus Federation of Pakistan. In this case, insertion of Article 175A was challenged. And therefore, the bench which was formed was of full court. All 17 judges, Chief Justice and all 16 judges sat in this case where the violations of certain provisions of the 18th Amendment was there. And in that case, what happened was that matter was partly decided and partly sent to the Parliament for adding 2 more judges to the Supreme Court under the Article 175A, and it was done under the 13th Amendment, 19th Amendment.
Citation
And therefore,
citation is
sir, citation is PLD 2010, Supreme Court 1165. The next, again, very important case is that of District Bar Association Rawalpindi versus Federation of Pakistan. PLD 2015, Supreme Court 401. In this case, vagaries of 18th and 21st constitutional amendments were challenged. And the 17-member by the full court sat on that and ultimately decided the petition against the objection, because it said that since by amendment, 19th Amendment, they have already added 2 judges under Article 175A. Therefore, that matter is rest. So now this is not a question of judicial independence. So therefore that was allowed. And the other matter in this was that of military courts for 2 years introduced under 21st Amendment, in which by 11-6 our petition was dismissed. But one thing very remarkable about is that actually the judgment, which is the main judgment on merits, I will be relying on that judgment, because there at least 14 judges out of 17 agreed that these are the basic features of the Constitution.
Salient features की बात की गई. Salient feature
की बात की, मगर वो अमेंडमेंट को अप्रूव कर दिया प्लूरिटी जजमेंट के अंदर भी और वैसे भी
वो कर दिया, लेकिन उसमें जहाँ तक defining the basic features of the Constitution, उस पर 14 judges were,
which includes independence of judiciary as well.
Independence of judiciary and separation of powers, the democratic system, all that. That was at least by 14 judges.
के अगेंस्ट तो होल्ड तो नहीं किया उसको उन्होंने
जी,
बेसिक फीचर के अगेंस्ट होल्ड तो नहीं किया उस 17 जजेस ने.
किया, मैं समझता हूँ किया. उसकी वजह यह है कि उसमें तकरीबन जो 6 डिसेंटिंग जजेस थे जो उन्होंने हमारे हक में फैसला किया था, उसमें 5 जजेस ने तो क्लियरली ये कहा है. एक जज ने went into altogether different tangent, Justice Khosa. So they did not consider that. But out of those so-called majority, 8 judges agreed with that there is basic features of the Constitution and anything against it can be struck down. They made an exception of the 21st Amendment by saying that since it has a sunset clause, that is, the military courts were allowed only for 2 years.
And again
therefore,
2 years.
They said we are ready to condone it. Otherwise, substantively they said that it should be struck down. Then, sir, next very important case in this regard is
ये जो salient feature की बात हुई थी 17 judges ने, now it will be considered a judgment of 17 members.
this is 17 by
salient feature की बात उसमें हुई थी.
जी, उसमें सर
अगर
14 judges थे.
जो मैं कहने वाला हूँ कुछ और,
जी,
अगर कोई उससे छोटा बेंच होगा तो उन salient feature को चेंज कर सकेंगे या नहीं कर सकेंगे? जो बात 17 ने कही है क्या वो 13 या 15 या 16 कर सकेंगे, यानी उसके अगेंस्ट जा सकेंगे या नहीं जा सकेंगे?
मैं नहीं समझता जा
और अगर उससे ज्यादा हो तो जा सके, 17 से अगर ज्यादा हो तो।
देयर हैज टू बी, ये 17 से ज्यादा, क्योंकि बेशक 14 ने ये बात कही है लेकिन वो जजमेंट तो 17
17 की, वो 17 की तस्वीर हो।
So need more than 17 to do
क्या आप
that.
खुश नहीं होंगे कि वो बरकरार रहे और 17 से एक छोटा बेंच हो?
So next judgment I'll be relying on is Justice Qazi Faiz Saab versus President of Pakistan. This is PLD 2021 Supreme Court 1. In this case, there were objections on some of the learned judges. So therefore, the full court was agreed upon, they agreed that there should be full court.
Please.
Court of 10 judges, because rest of them